Question 1. Explain legal framework for employment legal relationships. Answer. Employment legal relationships are regulated by the Constitution of the Republic of Latvia, the norms of international law which are binding on the Republic of Latvia, this law and other regulatory enactments, as well as by collective agreements and working procedure regulations. Question 2. Explain effective laws regulating employment legal relationships with respect to persons. Answer. This law and other regulatory enactments that regulate employment legal relationships shall be binding on all employers irrespective of their legal status and on employees if the mutual legal relationships between employers and employees are based on an employment contract. Question 3. Explain about employees. Answer. An employee is a natural person who, on the basis of an employment contract for agreed work remuneration, performs specific work under the guidance of an employer. Question 4. Explain invalidity of regulations that erode the legal status of employees. Answer. Provisions of a collective agreement, working procedure regulations, as well as the provisions of an employment contract and orders of an employer which, contrary to regulatory enactments, erode the legal status of an employee, shall not be valid. Provisions of an employment contract which, contrary to a collective agreement, erodes the legal status of an employee shall not be valid. Question 5. Explain the principle of equal rights. Answer. Everyone has an equal right to work, to fair, safe and healthy working conditions, as well as to fair work remuneration. The rights provided for in paragraph 1 of these sections shall be ensured without any direct or indirect discrimination, irrespective of a person's race, skin color, gender, age and disability, religious, political or other conviction, ethnic or social origin, property or marital status, sexual orientation, or other circumstances. In order to promote the adoption of the principle of equal rights in relation to disabled persons, an employer has a duty to take measures that are necessary in conformity with the circumstances in order to adapt the work environment to facilitate the possibility of disabled persons to establish employment legal relations, fulfill work duties, be promoted to higher positions or be sent for occupational training or the raising of qualifications, insofar as such measures do not place an unreasonable burden on the employer. Question 6. Explain the right to unite in organizations. Answer. Right to unite in organizations. Employees, as well as employers, have the right to freely, without any direct or indirect discrimination in relation to any of the circumstances referred to in Section 7, Paragraph 2 of this law, unite in organizations and to join them in order to defend their social, economic and occupational rights and interests. Affiliation of an employee with the organizations referred to in Paragraph 1 of this section or the desire of an employee to join such organizations may not serve as a basis for refusal to enter into an employment contract, for termination of an employment contract or for otherwise restricting the rights of an employee. Question 7. Explain the prohibition to cause adverse consequences. Answer. Prohibition to cause adverse consequences. It is prohibited to apply sanctions to an employee or to otherwise directly or indirectly cause adverse consequences for him or her because the employee, within the scope of employment legal relationships, exercises his or her rights in a permissible manner, as well as when if he or she informs competent institutions or officials regarding suspicions with respect to the committing of criminal offences or administrative violations in the workplace. If in the case of a dispute, an employee indicates conditions which could be a basis for the adverse consequences caused by the employer has a duty to prove that the employee has not been punished or adverse consequences have been directly or indirectly caused for him or her because the employee, within the scope of employment legal relationships, exercises his or her rights in a permissible manner. Question 8. Specify the time periods. Answer. Time periods provided for by this law shall be specified as calendar dates or time periods calculated in years, months, weeks or days. A time period may also be specified by indicating an event that will occur in any case. Question 9. What is the effect of a collective agreement with respect to persons? Answer. Effect of a collective agreement with respect to persons. A collective agreement shall be binding on the parties and its provisions shall apply to all employees who are employed by the relevant employer or in a relevant undertaking of the employer, unless provided for otherwise in the collective agreement. It shall be of no consequence whether employment legal relationships with the employee were established prior to or after the coming into effect of the collective agreement. agreement. An employee and an employer may derogate from the provisions of a collective agreement only if the relevant provisions of the employment contract are more favorable to the employee. Question 10. Explain familiarization with a collective agreement. Answer. An employer has a duty to familiarize all employees with the collective agreement not later than within a 1-month period from its approval or from the time of amendments made to the provisions of the collective agreement. An employer has a duty to make the text of a collective agreement available to every employee.